Imagine you are walking home, nothing unusual. A police officer stops you. He doesn't take you to a police station. He doesn't call forensic experts. He simply takes out his phone. You place your thumb on a small scanner. 35 seconds later, your identity appears on his screen. Not from Aadhaar, not from your phone, not from facial recognition, from your fingerprints. This isn't a scene from a report. It happened because of something called ABHIGYAN. Almost nobody is talking about it. And even fewer people are asking whether it is constitutional. Today, we are changing that. Here's the strange part. When this was launched, most headlines celebrated it. Crime investigation becomes faster. Technology modernizes policing. Identification in just 35 seconds. Those headlines aren't wrong. They are simply incomplete. Because every technological revolution creates another question. What does society give up in return? Let's understand what actually happened. In June 2026, during the 26th All India Fingerprint Conference, the government launched 4 digital platforms. Most people ignored them. One of them was called ABHIGYAN. Its job sounds simple. Give police officers mobile access to India's National Automated Fingerprint Identification System, or NAFIS or NAFIS. Think of NAFIS as India's fingerprint library. Only. This library contains more than 1.29 crore biometric records, fingerprints, palm prints, photographs collected over years. ABHIGYAN doesn't create the database, it unlocks it from the field. That's the difference. Now, here's where things become interesting. Imagine 2 situations. Situation 1, a fingerprint is sent from a police station to a forensic laboratory. Experts analyze it, reports are generated. The process takes time. Situation 2, a police officer standing beside you does the same thing on his mobile phone. Which one gives the state more power? That isn't a political question, it is a constitutional one. Whenever governments become more powerful, the constitution asks one question: what limits exist? That's exactly why privacy became a fundamental right. Not because privacy is fashionable, because technology changes faster than laws. When the constitution was written, nobody imagined smartphones connected to national biometric databases. But constitutional principles survive technological change. The Supreme Court anticipated this. In the Puttaswamy judgment, it doesn't prohibit technology. It simply asked 4 questions. Is there a law? Is there a legitimate objective? Is it necessary? Are there safeguards? Notice something. Technology isn't the issue. Unchecked technology is. Let's ask those questions first. Is there a law? Yes. India enacted the Criminal Procedure Identification Act. But here's the interesting part. The Act authorizes collection of biometric measurements. Does it specifically authorize nationwide smartphone-based field matching exactly the way ABHIGYAN now functions? That's a legal question, not a political opinion. Second question, is preventing crime a legitimate objective? Absolutely. Every constitutional democracy agrees. If technology helps identify dangerous offenders, society benefits. But constitutional law doesn't stop there. The difficult question comes next. Was this expansion necessary? Before ABHIGYAN, police could already access NAFIS. Now, that access becomes mobile. That changes something fundamental. The forensic laboratory has entered the street. Did the government publish studies explaining why this expansion became necessary? Has it published a proportionality assessment, a privacy impact assessment, an independent audit? Those questions matter. Now let's discuss something hardly anyone mentions: false positives. Every biometric system has them. Everyone. Even systems with 99% accuracy produce errors. Now think about scale. One database, more than 1 crore records, instant searches, 35 seconds. If a wrong match happens, what comes next? Can you challenge it? Can you demand re-verification? Who audits the software? Who checks whether misuse occurred? I searched. I couldn't find publicly available answers. Maybe they exist. If they do, they should be public. And here's the biggest constitutional question. Suppose you are completely innocent, never arrested, never charged. Can your fingerprint still be captured in the field? Under what circumstances? Who decides? What standards apply? Those answers determine whether this remains an investigative tool or gradually becomes a surveillance tool. To be fair, let's hear the government's arguments. Crime is changing. Criminals move from state to state. Technology should help police. Identification that once took days now takes seconds. That saves investigations. That saves victims. Those are powerful arguments. But constitutional democracies require something more. Power plus accountability. Imagine if tomorrow the government announced every CCTV camera will use AI. Every AI decision will remain secret. Nobody may question its accuracy. Would that concern you? Probably. The same principle applies here. Trust is strongest when systems are transparent. Here's what this debate is really about. Not fingerprints, not smartphones, not software. It's about constitutional design. Every generation faces one technology that changes the balance between citizen and state. This generation may be facing biometric policing. The real question isn't whether India should use technology. It should. The real question is, can technology become more powerful without constitutional safeguards becoming equally powerful? That's the debate we should all be having. Because the constitution doesn't exist to slow progress. It exists to make sure progress never outruns liberty. I am Amod Bidhuri and you are watching The Next Hearing. Thank you.